SwayamPrabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing the provisions from Bharatiya Nagarik Suraksha Sanhita 2023, which is the newer version of CRPC 1973. Today, in this session, we shall discuss search and seizure. Search of places and persons if required, and seizure of documents, things or articles. Now, we would be dealing with chapter 7 BNSS. The first part of this chapter deals with summons to produce document or other thing. Document or other thing. Now, section 94 and 95 would be dealing with this idea that a court, again as we have already discussed, court is both executive magistrate's court and judicial magistrate court, and police, if they require any specific article for the purpose of proceeding in that criminal case, then they would be issuing, the court would be issuing summons, police not be issuing summons, because the idea of issuing summons and warrants is associated with courts. Police does not issue summons or for that matter warrants. Police would be issuing orders to produce a particular specific thing to be produced before it by the person having possession of that particular article, document, thing or article. That is section 94. Section 95 deals with documents, letters, etc. lying with postal department. Postal department. How to procure something from the postal department, something which is required for or in connection with a criminal case. So that is summons to produce document or other thing. Section 94, 95. We would be looking for a specific article, document, etc. The next idea is that of a search warrant. Search warrant, again, it would, as I said, warrants would always be issued by court, executive magistrate, judicial magistrate, but then they may be issued to police to execute them. We would see further, there is a provision that it may be issued to police or to a private person also in some cases, wherein they would be searching a premises, and if required in that search, person therein may also be searched, if so deemed fit by the person executing search warrant. So the idea here is that the person himself is directed to produce the document or other thing. At this place, the court, because this is warrant, the court EMJM would be issuing search warrant that a police officer or a private person would go to that place and would search for himself. Of course, we will see the procedure thereafter. This is section 96 to 101. The next part is that of general provisions relating to searches, that is section 102 to 104, and then there are other miscellaneous provisions from 105 to 110. So, these are basically general provisions dealing with search and seizure. Search, that we search a place; seizure, that we seize something on considering it important for the criminal proceeding that we are currently undertaking. Now, the first section, as I said here, is section 94. It says, it talks about summons to produce document or other thing. Now, it says whenever any court or any officer in charge of police station. So, any court means executive magistrate court, judicial magistrate court, considers that the production of any document, electronic communication, including communication devices, which is likely to contain digital evidence or other such thing, are necessary or desirable for the purpose of any investigation, inquiry, trial or other proceeding under this Sanhita, of course, by or before such court or such officer, then it says such court may issue a summon, or such officer, as in police officer, may issue a written order either in physical form or in electronic form, and require the person in whose possession the document or that thing is believed to be, require the person to attend before such court or the police officer and produce that specific article, or not to attend, not to come before the court or the police officer, but to produce it through somebody else at the time and place stated in the summons or order. So, that person may produce the thing through himself or through any other person as required in the summon or the written order. Now, clause 2 says that if the person who is required under this section to produce a document or a thing, he shall be deemed to have complied with the requisition if he causes such document or thing to be produced instead of attending personally to produce the same. That we have already discussed, and clause 2 makes it abundantly clear that it may also be done. Now, let us discuss a few more things about section 94, clause 1 and clause 2. Again, I would repeat that the idea is to, require a person to produce certain documents or things before the court or the police officer. Now, a document or a thing in a criminal proceedings, of course, may be required either by the court itself or by the police officer. It may be required, say, by the accused. Suppose during trial, he wants to cross-examine a witness, and for that cross-examination, he needs a particular document or a particular material or thing, etc. Now, and of course, the document or other thing may be required by the prosecution as well. Kamal Ahmed Mohammed, Vakil versus State of Maharashtra, 2013, Volume 2, Bombay High Court, 217. The court said that the ambit of section 94 is wide enough so that all these agencies may be taken care of, including the accused and the prosecution. If they want any document or other thing which are in possession of a third person and they want it for the proceedings, they may apply to the court for getting them. So, if the document is in the court itself, the court would grant a copy of that document to such stakeholders, or if it is not there, then the court would use its powers under section 94 and shall require the person holding that document or other thing to produce before it so as it to be given to the respective sides. Now, sometimes the question arises that if a person appears before the court for producing a document or thing under section 94, is he a witness? As in, would he give statement, would he depose in the court, would he be cross-examined on that deposition, etc. The Supreme Court in Parmeshwari Devi versus State, AIR 1977, Supreme Court 403, observed that such a person who appears before the court or say before the police officer would not thereby becomes a witness, and he cannot be cross-examined, etc. by the court. Of course, the police would not be cross-examining him. I mean, the police does not have any business to cross-examine anybody. But then this question is more relevant for the person appearing before the court under section 94. Now, this case says, Parmeshwari Devi versus State, 1977, that such a person is not a witness and he cannot be cross-examined by the other party. Also, we must understand here that a person who has been ordered to comply with a summon or order under section 94, can he deny producing that document? Now, the idea is that if a person is summoned under section 94, as I stated earlier, then he is bound to produce that document under section 165 Bharatiya Sakshya Adhiniyam. Not only that, because he has been ordered or summoned to produce that document under a legal provision, section 94, that he is required to comply with that provision, but also section 165 says that he would be producing that document in the court, though he may raise his objections as to its admissibility in the proceeding and to its production also in the proceedings which are being conducted in the court. Now, as I earlier said in the beginning, that section 94 and section 95, they are meant for getting a specific article, document or a thing, and it cannot be a general search that can be conducted under section 94, 95. So, it must be for a specific thing. Also, it has been observed that the court or police cannot use such expressions as that it would say to a person, it would issue a summon or a document saying that you produce the stolen article, you produce the relevant stolen article which you possess. Such vague statements, I mean, this kind of statement cannot be passed in the garb of the power of the court or police officer, that it may ask a person to produce a particular document or a thing. The reason is because such expression would be running into Article 20 Clause 3 protection, which says that no one can be compelled to be a witness against himself. And here, this order would tantamount to compelling him, to produce the stolen article. That means to compel him to produce an incriminating evidence against himself, and that is a violation of Article 20 Clause 3. So, such expressions must be avoided. They are not legal expressions. They cannot be used in such orders or summons under section 94. Now, the Supreme Court in Shamlal AIR 1965, Supreme Court 1251 says, now in the same spirit, if we look at the position of accused in a case, now can he be required to produce a document or a thing under section 94? That question also emerges. Now, the Supreme Court in Shamlal case, 1965, Supreme Court, AIR 1965, Supreme Court 125, that if we issue an order or a summon to an accused in a case to produce something, then it would again be violation of Article 20, Clause 3, because such an order would tend to subject him to incriminate himself, and it is being done through compulsion. So, that would again be, there is a possibility that it would incriminate him, and so for compelling him to do so would be a violation of Article 20, Clause 3. Though we have a solution to that, but it is for sure that the accused under Section 94 cannot be asked to produce any document or material or thing. The solution appears to be in conducting a general search of the place occupied by the accused. We shall discuss it later. General search conducted by police, etc., or by any other person under search warrant. So, through that mode, we can lay our hands onto the required documents, article or things, and of course, they would be very, very necessary for taking the trial to conclusion. So, that can be done through general search under search warrant, and the provisions, as I said earlier, for search warrant are from 96 to 101 that we would see later. In that, a general search may be held even against the accused, and whatever is seized from a particular place would be taken to the court, but not under Section 94, that the accused can be compelled that he would be producing any document or a thing to the police or to the court. Under Section 94, that cannot be done. In this regard, if we look at a case by Supreme Court, Kathi Kalu, that is AIR 1961, Supreme Court 1808. Now, it makes a fine distinction between those document, material or thing which contains personal knowledge of the accused and those documents which do not contain any such personal knowledge of accused, and observed that it is only in the first case that if we compel some accused to produce a particular thing, only if it is a case where that particular document contains personal knowledge of the accused, that it would be violative of Article 20, Clause 3. Not in the second situation, where the article does not contain any such personal knowledge of accused. The reason is simple. Article 20, Clause 3 says no person witness against himself. Now, witness means that somebody is imparting his personal knowledge, somebody is sharing his personal knowledge with the court. So, if somebody is not sharing his personal knowledge, that which is in his mind, that he is not a witness. So, if we ask an accused to produce documents which do not contain personal knowledge, then it cannot be said that he is being made a witness against himself or that he is being compelled to be a witness against himself through that summon or the order. So, it seems there is an apparent conflict between Shamlal, that is in 1965 Supreme Court. The Supreme Court observed that an accused cannot be asked to divulge a document by an order under Section 94, and on one hand, and on the other hand, Kathi Kalu, that was in 1961, that the court, as I said, made fine distinction between the two situations and observed that it can be done in one of them. The legal provision, as in Section 94, 1 or 2, that does not mention about whether the summon or order can be issued against the accused as such. But then in Clause 3, the Parliament provided that such orders or summons cannot be issued in violation of Section 129, Section 130 of Bharatiya Sakshi Adhiniyam, that it says that nothing in this section shall be deemed to affect Section 129 and 130 of Bharatiya Sakshi Adhiniyam. So, no such order can be passed if the situation falls in these sections. Section 129 is, it says, unpublished documents, unpublished official record relating to affairs of state cannot be divulged to, cannot be given in evidence except with the permission of the head of the department. The permission of head of department is required. In the same manner, 130 Bharatiya Sakshi Adhiniyam says that communication to public officer in official confidence can also not be compelled to be disclosed. Communication to public servant in official confidence. So, if that communication, of course, if that communication is in writing, then it cannot be asked to be divulged. Then it says, or the Bankers Books Evidence Act 1891. Bankers Book, the relevant provisions of this act provide that in any legal proceeding to which the bank is not a party, no officer of a bank shall be compelled to produce any banker's book of which the contents can be proved, except by order of the court or judge made for a special cause. So, unless some permissions have been granted, unless here court records special reasons, such documents cannot be had and read in the court of law. Then it says that Section 94 would also not apply to any letter, any postcard or other document which is in the custody of the postal authority, and that gives, that is the precursor to Section 95. So, let us see Section 95. Now, it says, if any document, parcel or thing in custody of a postal authority is in the opinion of DM, he is on executive side, the others are on judicial side, CJM, Session or High Court, want for the purpose of any investigation, inquiry, trial, other proceeding under Sanhita, then such magistrate or court. Now, see, the police is absent here. Police powers, police have not been given power under Section 95 so as to require the postal authority to deliver any document, parcel or thing as these authorities may require it for a criminal proceeding. Clause 2 says, now this clause gives space to police, especially to the higher police officers, the Commissioner of Police or DSP, District Superintendent of Police, SP. So, Commissioner of Police or SP, and of course, magistrate, executive or judicial, that if they require, so this here JMIC would be included, JM second class would be included, executive magistrate would be included. You see, in clause 1, it was only CJM and higher that were contemplated. Here on judicial side, all magistrate, first class, second class, and on executive side, executive magistrate have been contemplated, and also the police is contemplated through its superior officers, that if they want any document for such purpose, as in for investigation, inquiry, trial under this Sanhita, they may require the postal authority to cause search to be made for that document, etc., and detain that document, etc., pending the order of DM, CGM or court under subsection 1. So, here under clause 2, the postal department would not be delivering the article to these authorities, but it will search it and keep it detained with itself, and if and when ordered by these offices that the postal department would then deliver the document, article, etc. to the agencies which would require it for the purpose of investigation, etc. Now, this is section 96, where we talk about search warrant for the first time. 94, 95 was not search warrant. It was not search warrant. It was asking the person or the postal authority to deliver something. Now, if we take a bird's eye view in this respect, then we would find that the search warrants are there in section 96, 97, 98 and 100 that we would discuss today. Apart from that, these are search warrants. Apart from that, searches without warrant would be section 185 BNSS, that is by a police officer without search warrant, that during investigation that he feels that if he would procure search warrant, then it would defeat the purpose of search, as in the required material would be disposed of or concealed, etc. Then he would record his subjective satisfaction, and after recording his satisfaction, that he can conduct search without search warrant. Without search warrant, that is section 185. There is another section where a search can be conducted without warrant, that is section 108 BNSS. Here the magistrate has been given power to conduct search in his presence. Now, section 108 says that any magistrate, and any magistrate then mean executive or judicial, may direct a search to be made in his presence, as I said, in a situation where for the search of which he may issue a search warrant. So, for which situation he may issue a search warrant, he may also cause that search to be made, but there is a condition that the search would be made in his presence. So, these searches are with warrants, these searches are without warrant, and of course, 94, as I said, 95 are not searches. They are not searches to start with. Now, with that view, let us start with the first section where a search warrant would be issued. It says, where any court has reason to believe that a person to whom a summon under section 94 or 95 might be addressed will not or would not produce the document or thing as required by some such summons or requisition, or that such document is not known to the court to be in possession of any person. In these cases, both here, if we read them carefully, the idea is again to get a specific thing from a place, from possession of a person residing in a place. And if we compare this, so searches under search warrant clause A, clause B would be conducted only for specified things. As in, if we read A, it says the document or thing for which section 94, 95 would not be of much use as the court thinks, or that such a document, such again links B to A, and the idea is again that of a specific thing that is required. So, issuing search warrant for a specific thing would be A or B, and issuing search warrant for a general search. A general search is conducted not for a specific thing, but it is conducting for a chance to get a relevant article, a document or a thing during that search, that it would be used in the criminal proceedings. And of course, the agencies are of the view that this place would be having such articles that would be found in such place that it would go to the court and would ask for a search warrant under 96C, that would be for a general search. It says court considers that the purpose of inquiry, trial, other proceeding under Sahita will be served by a general search or inspection. 96C search warrant would be for a general search of a place. Of course, it says then it may issue a search warrant and the person to whom such warrant is directed. Now see, it says person. So, search warrant may be issued to a police officer as well as a private person. Then he may search in accordance with and provisions contained. Then, if we look at clause 2, it says the court may, if think fit, specify in the warrant, as in search warrant, that a particular place or part thereof that to which the search or inspection shall extend, and then that particular part only shall be searched or inspected. Clause 3 says that nothing contained in this section shall authorize any magistrate other than a DM or CJM to grant a search warrant for a document, that parcel or other thing in the custody of the postal authority. So, only a DM or a CJM can issue a search warrant to be conducted for a document in the custody of postal authorities. Now, here let us discuss some more issues, as in MP Sharma versus Satish Chabra, AIR 1954, Supreme Court 300, MP Sharma versus Satish Chabra. The court observed that issue was whether such search warrants violate people's right to hold the premises. The court observed in negative and observed that no such right has been violated by issuance of these search warrants, because these search warrants are only temporary interference with such rights and they are for the limited purpose of investigation, and of course, they would be executed in strict manner as provided by the search warrant itself. However, of course, if they are found to be in excess, then it is a matter of redressal in a separate proceeding. The Supreme Court in 1980 in V.S. Kuttan Pillai versus S.V. Ramakrishnan, AIR 1980, Supreme Court 185, observed that issuing search warrant against somebody is a serious matter and it should not be issued in a mechanical routine way. A clear application of mind must be there. Also, it has been observed that these search warrants, now the issue was whether these search warrants would violate Article 20 Clause 3, and it was also answered in negative by the Supreme Court. The Supreme Court observed that Article 20 Clause 3 would be working only when somebody is compelled to produce something, compelled to produce, of course, something which is incriminating against him. If we look at the scenario of a search warrant, nobody is being compelled to produce anything. It is that the police is going to the place and it is searching for something, something as in some specific article, if it is under A, B as we discussed, or conducting a general search that we discussed, that is possible under clause C, 96(1)(c). So, nobody is being compelled to produce anything, and that is why the court said that it would not be violating Article 20 Clause 3. Now, the next provision is section 97. We will quickly go through it. It says that search warrant may be issued for searching of places which have been suspected to contain stolen property, forged documents, etc. So, here if you see district magistrate, SDM on executive side, JMIC on judicial side, they have been given power upon, and of course, after conducting such inquiry as they think fit, that if they believe that some such property is, lying at a particular place, then he may by warrant authorize any police officer. Here, if you compare it with section 96, here only a police officer has been entrusted with this task, that too above the rank of a constable, that he would enter that place, search that place, take possession of the property or article found therein, convey it to, of course, to the magistrate issuing the warrant, or to take it into custody and of course cause it to be produced in a reasonable time to the magistrate. These are the objectionable clause 2 provides a list of objectionable article for which this search warrant may be issued: counterfeit coin, pieces of metal in contravention, counterfeit currency, obscene objects, false seal, etc. The next provision is section 98, which says where any newspaper or book or any document appears to the state government to contain any matter, the publication of which is punishable under section 152. Section 152 is an act endangering sovereignty, integrity and unity of India. Section 196 is promoting enmity in different groups on grounds including race, religion, etc. Section 197, and these sections are from BNS 2023. Section 197 is about imputations prejudicial to national integration. Section 294 is about sale, possession, etc. of obscene books. Section 295 is about sale, etc. of obscene objects to child. Section 299 is about deliberate malicious acts intended to outrage religious feelings. Meaning thereby, if any newspaper, book or any document tend to commit any of these offences, then the state government by notification, of course stating the grounds of its opinion, declare every such copy of every such newspaper, book or other document to be forfeited to government. Every such copy forfeited to government. Now, here only state government has been empowered. No magistrate, no police officer, only state government. And upon such notification, then any police officer may seize the same articles wherever found in India, and any magistrate may by warrant, now this would be search warrant again, authorize any police officer not below sub-inspector to enter upon and search for the same in any premises where any copy of such material can be found or may be reasonably suspected to be. Now, if we look at clause 3 here, it says no order passed or action taken under this section shall be called in question in any court. So, this notification, this seizure by police officer or this search warrant cannot be called in question in any court otherwise than in accordance with the proviso of section 99. Now, we will see the provisions of section 99, but before that look at some more aspects of section 98. Now, it has been observed by the Supreme Court in Baragur Ramachandrappa versus State of Karnataka. This is 2007, volume 5, Supreme Court cases, page number 11, that the court said that this section is conceived in the interests of morality, decency, and the restriction does not hit Article 19 or is not hit by Article 19 of the Constitution of India. However, the right of freedom of speech and expression is a cherished idea under the Constitution, and so it must not be lightly interfered with by the state government. And so, whenever the state government issues any such notification, it must be based on some valid grounds capable of being examined by the court. I mean, it cannot be as that the notification is bereft of any reason, merely some ingredients of a particular section have been reproduced in the order, or say the order simply says, the notification simply says that because this article is prejudicial to national integration, so let us forfeit it. That is not possible. The state government should clearly formulate its opinion. It must state the grounds on which it has made that opinion that it would be not be in the public interest, that it would remain in the circulation. Now, let us see section 99. As we have seen before, that any order or action taken under section 98 can be challenged only as per 99. Now, we see what 99 says. It says that any person having any interest in any newspaper, book or other document, any person having any interest in such document against which of course the forfeiture order has been made under section 98, may within 2 months apply to the High Court to set aside such declaration. Then it says, so let us first discuss as to who would be such a person. Would it be the owner only, or it may be any other person? Now, Allahabad High Court in Anil Kumar Singh versus State of UP 2010 CRLJ 717 observed, Allahabad High Court observed that it need not to be the owner only, but it may be any person who might be holding a copy of that document, might be the owner of any such newspaper, book, article, etc. And of course, that he is interested in reading it, interested in discussing it with other people, etc., that he would be interested that such book would remain in circulation. So, any such person can take recourse to section 99 and can challenge such notification. Now, then it says High Court, such application would be disposed of by High Court consisting 3 or more judges, then it shall be a bench of 3 judges. Where the High Court has 3 or more judges, it shall be, the bench shall be consisting of 3 judges, and where the High Court does not have 3 judges, as in there are less than 3 judges in that High Court, then such bench would be having all the judges of that High Court, and then that bench would decide the matter, whether it actually tends to violate those laws, and if not found to violate such laws, then the High Court would set aside the declaration of forfeiture, that is the notification. Now, the next provision is section 100, and it says that DM, SDM on executive side, magistrate first class, judicial side, if it has reason to believe that any person is confined under such circumstances that the confinement amounts to an offence. So, suppose a woman is abducted, a major woman is abducted, a child is kidnapped, minor. Now, of course, it would be an offence and it would be tried as per BNS, but to recover such person who has been abducted or kidnapped, a recourse can be had under section 100, that the DM, SDM or JMIC would issue a search warrant to, again, it is a person here, not necessarily the police officer, that he would search for the person so confined, as in if they have reason to believe that any person is confined in the circumstances that it amounts to an offence, then such person would search for such person, and then if found, shall be immediately taken before the magistrate, who shall make further orders. Now, in the same spirit, if we see section 101, it says, now if you compare section 100 with 101, section 101 seems to be a matter of urgency. It says, if we read it, it says, if a woman or a female child is abducted or unlawfully detained for any unlawful purpose. So here, so if we compare it with section 100, section 100 says that it amounts to offence. Section 100, that the confinement amounts to offence. Section 101 says not only that this amounts to offence, that abduction, unlawful detention is there, but it is for unlawful purpose also. So, simply saying that the woman is abducted or the child is kidnapped would not qualify section 100, 101, but it must be proved that they are abducted, kidnapped, detained for unlawful purpose. That is, they are detained, abducted, kidnapped, etc. for, say, making them to beg or making them to act as a sex slave, that this section would swing into action. Now, if this is the situation, then these people, DM, SDM, magistrate first class, may make an order for the immediate restoration of such woman, female child, and may compel compliance with such order using such force as may be necessary. So, this is a matter of urgency, as I said. Force is also being mentioned, and immediate restoration has been talked about, compelling compliance has been talked about. So, it shows that it was a situation of urgency, that the agencies would swing into action. Now, let us quickly go through other sections. Section 102, which says that these sections would apply to search warrants also. Search warrants also. Now, these sections, if we look them in BNS, they would be like warrant would be signed, sealed, would be remaining in force till it is executed or it is cancelled by the court. 32 would say that public would aid such officer executing search warrant. Then 79, 80, 81 would say that such search warrant can be issued outside the territorial jurisdiction of the authority issuing it, etc. Then section 103, which is a very important section, and it is actually a safeguard for the people or the place against which such searches are made. If we look at the gravamen of this, if we look at the crux of this section, we find that it says that before making a search under this chapter, the officer or other person shall call upon 2 or more independent respectable inhabitant of the locality in which place the search is to be made. You know, and there are certain guidelines. They say that these witnesses to search would first be searched thoroughly, personally, as in their personal search would be conducted, so as there would not be any allegation that they were holding something on their person and then they planted it there. So, those persons will be searched and then they would take part in the search. There would not be stock witnesses. The search would be videographed. They would sign, the witnesses would sign the list of articles which is seized from that place, etc. And we find these things if we read these provisions. The idea is that the search would be conducted in a fair manner and the accused must not have a feeling that it was a planted search, as in the police planted something and declared it to be found from his place etc. Now, the next provision is section 104, which says that if search warrant is executed beyond territorial jurisdiction of the authority which issued it, then the person would execute the warrant and would produce it to the nearest magistrate, and such magistrate, unless there be good cause to the contrary, would cause such article to be taken to the court that issued the search warrant. Now, if we look at section other miscellaneous provisions, they are section 105 to section 110. Section 105 says that it should be recorded, searches and seizure should be recorded. Section 106 says that the police officer would have power to seize certain articles if they are suspected to have been stolen or which are otherwise seems to be involved in commission of a crime. So, then the police officer would seize them, as in there is no need of any search warrant here. This is keeping the urgency in view. Section 107 talks about attachment or forfeiture or restoration of property where the property seems to be the proceeds of crime. Here, the SP or the Commissioner of Police would make an application to the court that such and such property is proceeds of crime, and if the court finds it that it is actually a proceed after inquiry, show cause notice, etc., and if it is found, then section 107(6) and 7 says that it would be sold out and the proceeds would be distributed among those who are the victims of crime. Section 108, as I said earlier, it is a search without warrant conducted in the presence of magistrate. Section 109 is a power to the court to impound the documents produced before it. So, if some document is produced before a before a court, the court can impound it. Impound is taking legal possession of something. So, the court may retain it. Now, the next section is section 110. It talks about reciprocal arrangements regarding processes. It foresees 3 territories. The said territory, it says, which is that territory where BNSS applies. Then territory number 1, which falls in India, but BNSS does not apply, as we see section 1(2) of BNSS. It says that the BNSS would not be applying to the state of Nagaland and to the tribal areas, and territory 2, that is outside India. So, territory 1 is inside India, but BNSS does not apply, as I said, section 1(2). Territory 2 is outside India, and then it envisages the outgoing processes, as in from said territory to the court situated in these territories, that the search warrant, etc., which are sent from the said territory to these territories, and these territories would be executing them, and vice versa, as in these territories would be sending these warrants to the said territory and the said territory would be executing them. Thank you.
Hello and welcome to this piece of literary snippet. Today we are going to read a section from Virginia Woolf's novel Orlando. And the section that we are going to listen to today is perhaps one of the finest descriptions of the winter season in English literature. It is also a very fine piece of what we call fantasy writing. I have made a few changes to the original to adapt it for the purpose of reading. Was, historians tell us, the most severe that has ever visited these islands. Birds froze in mid-air and fell like stones to the ground. At Norwich, a young countrywoman started to cross the road in her usual robust health and was seen by the onlookers to turn visibly to powder and be blown in a puff of dust over the roofs. And cattle was enormous. Corpses froze and could not be drawn from the sheets. It was no uncommon sight to come upon a whole herd of swine frozen immovable upon the road. The fields were full of shepherds, ploughmen, teams of horses, and little bird-scaring boys, all struck stark in the act of the moment. One with his hand to his nose, another with a bottle to his lips, a third with a stone raised to throw at the ravens, who sat upon the hedge within a yard of him as if they were stuffed birds. The severity of the frost was so extraordinary that a kind of petrification sometimes ensued. It was commonly supposed that the great increase of rocks in some parts of Derbyshire was due to no eruption, for there was no eruptions. Rather, it was supposed that they were due to the solidification of unfortunate wayfarers who had been turned literally to stones where they stood. The church could give little help in the matter, and though some landowners had these relics blessed, the most part preferred to use them either as landmarks, scratching posts for sheep, or when the form of the stone allowed, drinking troughs for cattle, which purpose they serve admirably for the most part to this day. But while the country people suffered the extremity of want, and the trade of the country was at a standstill, London enjoyed a carnival of utmost brilliance. The new king directed that the river, which was frozen to a depth of 20 feet, should be swept, decorated, and given all the semblance of a park or pleasure ground, with arbors, mazes, alleys, drinking booths, all at his expense, of course. Frozen roses fell in showers when the Queen and her ladies walked abroad. Colored balloons hovered motionless in the air. Here and there burnt vast bonfires of cedar and oak wood, lavishly salted so that the flame were of green, orange, and purple fire. But however fiercely they burnt, the heat was not enough to melt the ice, which, though of singular transparency, was yet of the hardness of steel. Was the ice that there could be seen congealed at a depth of several feet, here a porpoise, there a flounder. Shoals of eels lay motionless in a trance, but whether their state was one of death or merely of suspended animation which the warmth would revive, in short, nothing could exceed the brilliancy and gaiety of the scene by day. But it was at night that the carnival was at its merriest. The nights were of perfect stillness. The moon and stars blazed with the hard fixity of diamonds, and to the fine music of flute and trumpet the courtiers danced. See you in the next episode of Literary Snippet.